Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. We are coming to you from our beautiful central Washington location, but that's about the only thing that's going to be beautiful about this video. Oregon, this video is for you. Now, it's been a while since we got to talk to you. It's been a while since we talked about Ballot Measure 114. As you know, that matter went to trial in Portland a few weeks ago. We have the rulings. The rulings were issued today, and it is a double strikeout for the plaintiffs here. A judge has, in fact, upheld all portions of Ballot Measure 114, so we're going to get you all up to speed. So today, let's spend a few minutes and talk about how the agony of Ballot Measure 114 will continue for all of Oregon. Okay, so what we're talking about is the case of Oregon Firearms Federation v. Kotek. It was a case that was filed in the United States District Court for Oregon in Portland. It was before Judge Karen Ermagert. Now, you can go look this up for yourself. Judge Ermagert was a Donald Trump appointee and a claimed Republican. So one would think that the plaintiffs had, at least a puncher's chance here. Oh, no. Not at all. And as a matter of fact, if you want to do one little exercise here, go ahead and use the Control F function and type in the terms, "the court agrees with the defendants," because you will see that that term is used throughout this entire opinion over and over and over. Now, the two big issues that were being argued here in this particular challenge to Ballot Measure 114 was, number one, the large capacity magazine ban, and then number two, the pre-purchasing licensing requirement. Judge Ermagert has found that both of them withstand constitutional scrutiny and has essentially dismissed the lawsuit against the state of Oregon. Now, how could the judge uphold a large capacity magazine? Well, it took some real mental gymnastics and some intellectual dishonesty, but yes, I can assure you that Judge Ermagert got there. One of the things is we start thinking about the common use test, right? I mean, well, of course, these things are in common use and therefore they can't be banned. Heller says that, right? Well, what Judge Ermagert said is just because millions and millions of Americans own them, that's irrelevant. You see, how commonly are they used in self-defense? Or as Judge Ermagert put it, by contrast, the defense presented substantial and highly credible evidence at trial showing that the ordinary civilians in self-defense situations rarely fire more than 10 rounds. And so it is the classic, you don't need any more of that argument. But no, she didn't stop there. Because in weighing both the plaintiffs' expert opinions, people in the firearm industry that really understand not only the industry today, but the history of the industry, versus some of the liberal academia that the defense brought to the table here, well, this is how the court was persuaded to attach far more weight to the defense evidence. Defendants' experts come from the neutral academic backgrounds and possess no economic interest in the sale of LCMs. The plaintiff's evidence, by contrast, offers a curatorial perspective on the evolution of firearms technology in the United States, including personal experience handling firearms from different eras. Essentially stating, hey, listen, I like what the defense witnesses had to say more, so therefore I'm going to attach far more weight to that, and I'm just going to discredit the plaintiff's witnesses. Now, there's more, because the court did find that there is a long and rich historical tradition of regulating large capacity magazines. And I know you sit there and you go, well, wait a second. How could she have found that from the late 1700s? Oh, she didn't. She didn't, because when Judge Ermagert decided that she was going to go back and take a look at the history, yes, she looked at the history from the late 1700s and the early 1800s and the Reconstruction era. But she also looked at history from the 1900s, both early 1900s as well as more modern recent times. In drawing her disingenuous conclusions of law, the judge actually found that magazines, large capacity magazines, are not even protected by the Second Amendment because they do not constitute bearable arms, or as the court ruled, even if the court were to find LCMs are bearable arms, that would not end this court's inquiry into whether LCMs are covered by the plain text of the Second Amendment. In considering the scope of the Second Amendment right, the Supreme Court in Heller emphasized that it protects an individual right to keep and bear arms in common use for lawful purposes like self-defense. This court considers whether plaintiffs have shown that LCMs are in common use and whether they are in common use for self-defense. Okay, that's right. And I want you to pay attention to this reasoning because you know you're going to see this pop up in other rulings. The court is saying, hey, there may be millions and millions of these large capacity magazines, but because there's not sufficient evidence to establish that they are in common use for self-defense, remember the case law is common use for self-defense and other lawful purposes. However, the court wants to isolate a few words to get to the result they want. Since no one can establish that they are in common use for self-defense, the entire Second Amendment doesn't even cover them. As the court put it, this court finds that while magazines that hold more than 10 rounds of ammunition are owned and possessed by millions of Americans, this fact alone does not automatically entitle these magazines to Second Amendment protection. This court rejects plaintiffs' invitation to equate commonly owned with in common use today for self-defense. Well, I know you guys are all rolling your eyes. Some of you might even be grabbing the barf bags already, but you sit there and I know what the counter argument is, well, I use my large capacity magazines for self-defense, or at least that's what I would intend to use them for. It's in my everyday carry firearm, therefore I would use it in defense of myself, my family, or others. Well, the court basically said, hey, you know what? That's irrelevant. This is how they put it. The question is whether plaintiffs have shown that LCMs restricted by BM 114 are in common use for self-defense based not only on the subjective belief of individuals who possess LCMs, but also on the objective evidence related to LCM use in self-defense. This is how the court reached that conclusion. While the average number of shots fired in self-defense is around 2.2, in a mass shooting involving an LCM, the average number of shots fired is 99. And while more than 10 shots are fired in just 0.3% of defensive gun uses, more than 10 shots are fired in 94% of mass shootings where an LCM is used. Thus, while it is uncommon for an individual to fire more than 10 rounds in self-defense, it is common for mass shooters to fire more than 10 rounds, especially when the mass shooter is using an LCM. I literally cannot make this stuff up, okay? That is the reasoning by which the court believes that large capacity magazine bans are constitutionally permissible, but there's more, because the court actually goes so far as to make a finding of fact and a conclusion of law that large capacity magazines actually constitute dangerous and unusual weapons. So they're in common use, but they're not in the kind of common use that we would have constitutional protections for. But even if they were, they're also dangerous and unusual. And you can see how the court here just essentially structured as many remedies as they possibly could to get to their desired result. And of course, the court relied on the age-old argument that the founding fathers could have never envisioned the technological advancements that would be made in firearms, which may be true, but they also would have never envisioned the types of technological changes made in communications, thus protecting or not protecting your First Amendment rights, your freedom of religion and all the modern religions that we have today, all the forms of surveillance that exist today as opposed to what existed in the late 1700s, the types of cruel and unusual punishments that's available today as opposed to what could be inflicted upon a person in the late 1700s. And we go on and on and on, but that is the selective interpretation of how the Constitution works according to this judge. Now, I know you're also asking about the pre-purchasing licensing requirement, right? They struck that down because there is no other constitutional right out there where you actually have to go out and demonstrate proficiency and get somebody's permission before you could go exercise the right. So that was struck down, right? No, it was not. As a matter of fact, the court basically said, hey, listen, what Oregon is doing here is really akin to a shall issue state. They're basically going to give everybody this license. We do not know that to be the case at all, but the judge here believes that to be the case, and so therefore it does not violate the Second Amendment, it does not violate the 14th Amendment, it does not violate the Fifth Amendment, it does not violate anything. It is totally good to go, just like the large capacity magazine bans are as well. So the news out of Portland today is not good. Judge Ermagert, a Donald Trump federal appointee, has absolutely shot every one of plaintiffs' arguments down, has literally agreed lockstep with every single argument offered by the government in this case. The case, once again, is Oregon Firearms Federation v. Kotek. Now, we're going to put links for all of that stuff down below. Obviously, this is not the end. We do anticipate that there will be further appeals, but we will keep you posted. In the meantime, if you guys got any questions about this or anything else related to what's left of our Second Amendment rights, you should know how to contact Washington Gun Law by now. But if you don't, that's okay. That information is right down there in the description box. In the meantime, I do want all of you to remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, keep fighting, Oregon, and stay safe.